So I will deal with the judgment in two parts. One is the very following. 19(1)(a) recognizes our fundamental right to freedom of speech and expression. Article 19(2) says that reasonable restrictions may be imposed on 19(1)(a) through an existing law or by making a new law, imposing reasonable nine enumerated grounds. In the entire Constitution, there is no other basis to limit our freedom of speech and expression except 19(2). There is no other provision which authorizes the state or the judiciary to limit our freedom of speech and expression. Now, so you can only do it under 19(2), and only through a legislation which establishes reasonable restrictions. Now, in the case of contempt of court, which is one of the 9 enumerated grounds in 19(2), a law was enacted, and the law has defined what is criminal contempt, and has therefore under 19(2) imposed set of reasonable restrictions on 19(1)(a), according to the Constitution. There is no other way to restrict freedom of speech except through the Contempt of Courts Act, because only the Contempt of Court Acts fits the requirement of 19(2) that speech can be restrained only through reasonable restrictions imposed through a legislation. It cannot be imposed under the inherent powers of the Supreme Court under Article 129. It is a colonial, pre-constitutional inherent power which is inherent in courts of record, inherent power of courts of record, and that stands modified and subordinate to Part 3 of the Constitution, which is supreme. Article 13 of the Constitution says that no law that prevailed, that was in force in India before the Constitution, survives except to the extent it is not inconsistent with the fundamental rights. And therefore we can say the inherent powers of the Supreme Court have, through Article 13, been modified and made subordinate to Article. Sorry, sir. One second. Okay. Article 19(2) provides the framework for reasonable restrictions to be placed on 19(1)(a), and that framework is only the Contempt of Courts Act. And the inherent powers of the Supreme Court, while they continue for other types of contempt not related to freedom of speech can only be constrained through the Contempt of Courts Act. So the Supreme Court, when it restrains freedom of speech, cannot act under its inherent powers. It has no power to restrain speech except through the Contempt of Courts Act. And in this judgment, they explicitly say, the judgment says, we are not acting under the Contempt of Courts Act. So that is really one of the very important considerations which has not been considered in the judgment or raised in the court. But I believe it is very, very important for us to keep in mind, because we do not want to accept the precedent that the Supreme Court has an inherent power to limit freedom of speech and expression under 19(1)(a). It does not have such inherent power, and we must not accept that, and otherwise it has very dangerous implications for us. Last point on the judgment is that the judgment imposes, firstly, it sets out 13 judgments which deal with the question of when speech about judges amount to contempt, starting from 19 1953 Brahma Prakash Sharma versus UP, right down to a 2020 judgment. But in these 13 state judgments, there are principles of law on what kind of speech, and I'll come to that, what kind of speech amounts to contempt of court. But those standards are not applied or are partially applied, and the judgment uses very vague standards like, the speech should not affect the trust and confidence of judges in each other, of lower court judges in the Supreme Court. Now, how do I know what speech of mine will demoralize the judge? And so these are very vague standards, and I have argued in my article that there is a well-accepted international standard that laws, especially criminal laws, and Professor Call knows this better, cannot be vague. Cannot be vague. And there is a test for criminal laws called void for vagueness. If any criminal law is vague, it is void. So this judgment is void for vagueness, and that is another reason why this judgment is legally unsound. So these are the four reasons why I would say that this judgment is bad in law. I would now like to move quickly to two larger issues, which I think we need to reflect on as well, two larger legal issues. And the first is, this has impact on judicial accountability, this judgment, which is a big issue for us. I think we are all agreed that standards of judicial accountability are very minimal in our country, are very low in our country, and we need to enhance compared to any other judiciary in any democracy. We need to enhance and strengthen our standards of judicial accountability. So this judgment, which lowers the bar and makes two tweets, which do not clearly meet established standards of contempt according to the precedents and the law, if those are treated as contempt, then I think our ability to hold judges accountable is going to be further set back. Now, this judgment itself refers to the 1953 Brahma Prakash judgment, which frames the issue as, can you reflect on the character or conduct of a judge? What are the limits? Are there any limits? And if so, what are the limits when you reflect on the character or conduct or competence? They did not use the word competence. I would include competence also. Can we reflect on the character or conduct or competence of a judge? Now let's take a doctor. Doctors are as important to us as judges. Our life depends upon the character, the conduct, and the professional conduct and the competence of doctors. What if we were told that we can never reflect on the character, conduct, or competence of doctors, and we go to jail if we did that? And we are prohibited from saying this doctor is a bad doctor. Is it in the public interest or not? This is really an issue of how do we hold a profession? The judiciary is a profession. It has a constitutional role, but basically it's a profession like the legal profession. So we have to have standards of professional accountability when we talk of judicial accountability, even if you're actually discharging a constitutional role. Take the Comptroller and Auditor General of India. They are a profession. They have a profession, accounting and audit, but they have a constitutional function. We have to ensure that their professional accountability as accountants and auditors is enforced strictly if the CAG is to function effectively. Similarly, we must ensure that the professional standards as lawyers and as judges, as judicial professionals and legal professionals must be strongly maintained for judges if the legal system is to have is to be effective in our country, and that is weak, and this sets it back. That's the first point. The second point I want to talk about is what are the implications of this judgment for freedom of speech? in general. And I'll come back to that as well. But on the first standard, very brief, or first issue I raised of judicial accountability, if you take the precedents which have been set out in this judgment, these 13 judgments that have been cited here, there are also several judgments written in which are included in the Justice Karnan judgment. And there, not only the majority, the main judgment, but also the concurring judgment of Justice Chelameshwar is worth reading. So they set out these principles. Now, I think we can extract from that one, which is that the speech regarding the conduct and character and competence of judges should be prohibited to the extent that it affects the administration of justice or the confidence of people in the administration of justice. This is the principle. I'm not saying that's correct, but that is the principle that emerges from all these judgments. That if you say something that affects not the mere administration of justice in terms of actual process, but people's attitude towards the judiciary and confidence in the judiciary, and it erodes that confidence or their respect for or regard for or faith in that system, then people will not, the judiciary will, and here it's different from medicine, will lose its authority. Authority meaning its ability to obtain compliance with its orders and judgments. So if people don't respect it, respect the judiciary, if people don't give due regard to the judiciary, then judiciary's orders will not be followed and the judicial system will become ineffective. This is the argument. And in fact, one of the judgments asserts this legal principle, salus populi suprema lex. Namely, salus means welfare. The salus populi means welfare of the people. Suprema lex is the supreme law. That ultimately all the supreme legal principle is the welfare of the people. So obviously, if there is no welfare of the people issue involved in criticism of conduct or character of a judge, then it becomes a matter of defamation, personal defamation. The judge feels hurt, he feels defamed, then his remedy is in a court of law to seek, to file a suit for defamation. But when speech crosses that border and affects the welfare of the people by reducing the effectiveness and authority of the judicial system and its administration, then it becomes a matter of contempt of court. Now the question is, how do we know how to draw the line on this principle? The first thing we need to have is, we need to have some data and information, some facts on what is the current level of confidence that people have in the judiciary. And then we have to see what kind of speech is actually affecting it. And the speech that affects it or can reasonably be likely to affect it can be restricted if there is some evidence for it. But here the judges are asserting in this judgment and in many other judgments that people have great faith in the judiciary, and that great faith will be diminished by these two tweets and other such speech and action. But where is the evidence for that? So the first thing is, I think, if we have to, because we are toying with people's freedom of speech, which, as Mr. Safi Mohan said, is one of the most important freedoms in a democracy such as ours. And so we are tampering with the Kohinoor of our fundamental rights, our freedom, our liberty of speech and expression, and we should do so not rashly or not in an unruly manner, but with great precision and great caution. So if the judiciary is telling us that we cannot speak in a manner that affects the confidence of the people, then the judiciary must allow us academics to do research on what exactly is the state of confidence of the people of this country in the judiciary, and what kind of actions are helping improve and maintain that confidence, and what kind of actions, whether by the judiciary, whether by judges, whether by politicians, whether by business or common people, are eroding that confidence. So I think we must be allowed to do research so that we can have a proper basis on which we can then say, okay, what kind of speech should be restricted. The second related point there, which I write about in my article also, is we should not use this principle of tendency that is in the Contempt of Courts Act. Speech that has a tendency, not speech that has imminent impact or proven impact, because we are now moving towards arbitrariness. Anyone can feel that there is a tendency for confidence to be affected. So therefore, we have to, as I've argued in my article, give up this bad point, which is about freedom of speech, the bad tendency principle, and we must develop a much tighter test that will restrict speech more, because the bad tendency principle expands the ability to restrict speech and reduces our freedom. Even if I say something, but it's clearly not having an impact on the confidence of people in the judicial system, but it may have a tendency, then it can be restricted. But if the tendency standard is avoided, then I will be free to speak. So we have to, if necessary, amend the Contempt of Courts Act and say that this excessively interferes with our freedom of speech. Now, let me come at the end to the question of the impact of this judgment on liberty and freedom of speech. And I think this is a very, very important issue. I think we come from a society that has had till 1950. After 1947, we were without a constitution. Although we acquired our freedom, it was only in 1950 that we got a clear recognition of our liberty and our freedom of speech and expression. We come from a society which does not have adequate respect for freedom of speech, and which may have many of our traditions, not all our traditions, especially our ruling traditions, our Chaturvarnya system, our Maharajas, our Mughal emperors, our British colonialists. All of them have had contempt for freedom of speech, or for the masses, for common people. Freedom of speech for common people. Freedom of speech for educated elites is fine, but freedom of speech for common people is not something that we have to respect. So yes, we must respect courts. We must respect the dignity of courts. We must not insult courts, but we must also have commensurate respect, or even greater respect, for freedom of speech. And we must inculcate that value of freedom of speech if our democracy is to survive. And here, ironically, the judgment is saying by restricting speech, they are going to save democracy. I would argue it is the opposite, that if they want to protect democracy, they must actually expand speech and make speech as free as possible. Here, again, I will make my last and concluding point, that the big issue I see is that we do not have, unlike, say, in the United States, we do not have an overarching constitutional legal principle on restriction of freedom of speech. We have different standards for each of the grounds of 1902, the 9 grounds of 1902. So, for example, we are now talking about a restriction on 19(1)(a) based on a narrow question of what kind of speech will erode the confidence of people in the judicial system. And that standard itself is vague. But there is a standard being given to us that you cannot speak about judges in a manner that will erode the confidence of the confidence of the people in the system. Similarly, in other areas, we have of speech under the 9 other areas, and I'm not getting into those details. We have different particular separate standards on what restrictions are reasonable on speech. In contrast, in the United States, starting from the dissent of Oliver Wendell Holmes in Abrams versus United States in the about 100 years ago, they started to develop an overarching principle on protecting speech, and the principle laid down in the in Abrams versus United States was the clear and present danger, which challenged the bad tendency test, and there was a period when these two tests were in collision with each other because bad tendency test was seen as limiting freedom. But ultimately, in the 1960s, 62, I believe it is, in a case called Brandenburg versus Ohio, the United States had adopted an overarching test on what is a permissive restriction on speech, which is the imminent lawless act. When that speech is the source of imminent lawless action, So that is a slightly different standard from clear and present danger, more tight standard. So then we can adopt this standard and say no restriction on freedom of speech should be placed under any condition, under any law, under any power by the executive or the judiciary or the legislature, unless it meets the imminent lawless action test, for example. And therefore, even actions taken against us for sedition or other crimes can also be tested against the imminent lawless action test. Because even in sedition now, basically, we are using the bad tendency criterion and not the imminent lawless action criterion. So we need an overarching principle of law that will protect our freedom of speech to the maximum extent possible, except where our speech results in imminent lawless action. This is a very big gap in our law, and I think we should, as academics, turn our attention to this and ensure that we shore up and strengthen the protection of our freedom of speech, which is under huge attack in our country, not only with reference to judicial accountability, but with reference to many other areas of free speech. Safi sir, I'm stopping here.